if the government were to be allowed to prevent the Wall Street Journal or other news outlets from printing the facts, then that prevents the public from having a full account of the truth.
In the controversial 1931 Near versus Minnesota Supreme Court case, J. Near and Howard Guilford, publishers of the Minneapolis Saturday Press, debated the 1925 Minnesota Public Nuisance Law, arguing that it violated their rights to freedom of press and speech. The debate hinged on the gray area between libel laws and censorship. In the Minnesota Supreme Court, Near and Guilford were convicted of violating the so-called gag law. They then appealed to the United States Supreme Court, debating the constitutionality of the public nuisance law and ultimately overturning the Minnesota ruling. This was a success for publishers nationwide. The Near versus Minnesota decision has been successfully used as a foundation for many Supreme Court cases throughout history and as a consequence has preserved the freedom of the press in the United States. In the early 20th century, gambling, prostitution, and crime riddled the streets of Minneapolis. In his book, The Shame of the Cities, Lincoln Steffens described Minneapolis as a town where the people were drunk, satisfied, and left the law enforcement and the running of the city to the corrupt politicians and strong-armed gangsters. In response to the political and social corruption of the time, yellow journalism emerged on a national scale. Yellow journalists fueled unrest and sparked debate by exposing and often exaggerating political and social issues to promote change. In Minnesota, Howard Guilford and J. Near were two such journalists who worked to startle the public with vicious articles that attacked Minneapolis and the men who ran it. These publications became problematic under the Espionage Act of 1917, mandating the discontinuation of any articles that undermined the war effort. Near and Guilford were consequently moved to co-found the weekly newspaper, the Saturday Press, announcing their fearless devotion to reform the reputation of Minneapolis through exposure of crime and corruption. However, Near and Guilford were not innocent journalists crusading for truth. They were involved in blackmail and affairs, and the paper itself arbitrarily accused the mayor of demoralizing the police force and the police force itself of conspiring with the Jewish gangs. Near and Guilford instigated unfounded fears and concerns among the public. Through the Saturday Press, Near and Guilford challenged gangsters and public officials alike. In a string of heated articles, they challenged Minneapolis Police Chief Frank Brunskill because of his attempts to ban the paper from newsstands. With emotions and tensions rising, the controversial Minnesota Public Nuisance Law was enforced, making any malicious, scandalous, and defamatory publishing illegal. This law intensified controversy and debate between public officials and crusading journalists, while the Roaring Twenties began as a time of outspoken expression. As the depressed 30s neared, journalists began to face silencing restraint. Officials, including Brunskill and Minneapolis attorney Floyd Olson, were enforcers of this restraint, advocating that the government has the right to prevent articles from being published to protect civil order.
But when you think about the Minnesota law that was in question, that's really what that law was about. That was really sort of a smokescreen to say, well, we're going to say we're blocking scandalous material. What we're really trying to do is prevent the scandals we're involved in, keeping them from becoming public. Somebody who speaks truth to power is always very frightening to power if power has something to hide.
Guilford continued to criticize Olson and threatened, "Now go ahead and run for governor, Floyd, and you'll find that what you took to be a chip on my shoulder is really a tomahawk." Olson had finally had enough and was no longer willing to tolerate Near and Guilford's outrageous antics. He wielded the Minnesota Public Nuisance Law to make his case, claiming that the Saturday Press was exactly the kind of publication that the law prohibited. In May 1928, the Minnesota Supreme Court ruled that Near and Guilford had undoubtedly violated the Public Nuisance Law. Chief Justice Samuel Wilson said that there can be no doubt that the police powers include all regulation designed to promote the public welfare and prosperity. Wilson then issued a permanent injunction against the Saturday Press as well as any other publishing by Near and Guilford. This failure had left their careers moribund, but they continued to fight for free press with steadfast determination. Near and Guilford were not alone in their plight. Throughout the nation, journalists were active in the crusade against censorship. Robert McCormick, publisher of the Chicago Tribune, was an active advocate for freedom of the press. After becoming aware of Near's case, McCormick revived it by sponsoring Near's legal fees so he could appear before the United States Supreme Court and fight against the silencing public officials of Minnesota. Instead of arguing for their freedom of speech as guaranteed in the First Amendment, Near and Guilford shifted the debate to the Minnesota Public Nuisance Law itself, claiming that it violated the 14th Amendment and that it was a state law infringing upon civil liberties. According to Near, every person does have a constitutional right to publish malicious, scandalous, and defamatory matter, though untrue and for unjustifiable ends. The presiding justice of the 1931 Supreme Court case, Near v. Minnesota, Charles E. Hughes, said that, "The fact that liberty of the press may be abused does not make any less necessary the immunity of the press from prior restraint. A more serious evil would result if officials could determine which stories can be published." It was debated whether freedom of speech should be upheld, bearing in mind Near's questionable morals and motives.
My view is it's far better to have that information, that those ideas, even if they're offensive and hateful, out there so that they can be subjected to public discussion and debate.
On June 1, 1931, the debate came to rest. In a 5-4 decision, the court ruled that the right to freedom of speech and press was inalienable. It ruled in favor of Near, successfully reversing the Minnesota ruling and repealing the Public Nuisance Law of 1925. The court stated that, "For these reasons, we hold the statute to be an infringement of the liberty of the press guaranteed by the 14th Amendment, and imposes an unconstitutional restraint upon publication."
Tremendously important decision because it established a principle that had not been established in U.S. law before, which is that when the government attempts to stop people from speaking, that is, when they attempt to impose a prior restraint, that the courts will presume that it's not constitutional to do that.
Near v. Minnesota has been a success for American publishers throughout history and continuing today. The decision demonstrated the failure of Minnesota's attempted censorship and successfully solidified the right to freedom of speech and press. Consequently, it was an indispensable foundation for the Supreme Court case New York Times Company v. the United States of America in 1971, which protected the newspaper's right to print any material it had in its possession, including that which the government had deemed confidential. This case removed even more possibility of prior restraint laws suppressing the voices of journalists. However, the fight for free speech that stemmed from Near and Guilford in Minnesota to Woodward and Bernstein in the Watergate scandal continues to be fought today. The debate over food libel laws rages on and has significant consequences for citizens and journalists alike who criticize the food industry. Though the fight for free speech has changed and evolved over time, the precedent created by Near v. Minnesota still has a significant impact on journalism today.
The government cannot order a newspaper publisher to not publish something that's in the public's interest. I don't encounter government officials thwarting those principles or something each day, but they do. But I know that those principles are there, enshrined in the law, and like I said, provide sort of some basic ground rules by which we all operate. And so I think that's still very important.